I'm glad you asked that, Shep. Nobody's really asking on the ground as a person.
The Fifth Amendment of the Constitution protects him from speaking.
Hello, my name is David Bruno. I'm a partner at the Bianchi Law Group. With me is the former Morris County prosecutor and my partner, Bob Bianchi. Hi, Bob.
How you doing, Dave? Great to be here.
All is well. We are criminal defense, domestic violence, municipal court attorneys in the state of New Jersey, and our office is in Parsippany, New Jersey. Bob was the former head Morris County prosecutor. I was an assistant prosecutor in Morris County. And with that came experience on the law enforcement side that allows us to transition into the criminal defense world. And we are a team of former prosecutors who aggressively fight the government when our clients are charged with crimes. Today, we're going to be talking about pretrial intervention. And it is a diversionary program at the Superior Court for crimes. And it's a prosecutor's program. It allows prosecutors to take cases out of the criminal justice system, take it away from prosecution to a diversionary program where if a defendant completes the program and the conditions attached to it, the charges will be dismissed. So it's an excellent option for first-time offenders or people that are eligible for the pretrial intervention. And we use it when we can as defense attorneys. Bob, as the former head county prosecutor, you are responsible for ultimately approving all of the plea offers, including pretrial intervention admissions. So I'd like you to talk about this program from your experience as a former prosecutor.
Right. So what Dave said is right. It's we get asked this question a lot in our criminal defense practice because people hear the acronym PTI, which stands again for pretrial intervention. And like Dave said, it's a diversionary program. People want to know what it's about. Essentially, this program was developed many years ago as a way of treating low-level offenders to go into this diversion or movement away from the full, throated prosecution into this diversion where you could be monitored by probation for a certain period of time and with certain conditions attached to it, maybe fines, drug testing, keeping a job. But essentially, if you successfully complete the program, at the end, the case against you is dismissed. And the philosophy of the legislature in creating the program and the Supreme Court in running it was to give prosecutors an option to pick out those people who meet a certain criteria, and the criteria is kind of complex, but if you fit within that criteria, to apply. And then this way you can unburden the criminal justice system with so many low-level offenses, and by the same token, benefit a defendant who has otherwise led and will continue to lead a law-abiding life without having to deal with the dramatic collateral consequences that can stem from either a prison sentence or a record which attaches to you and makes your life very difficult down the road when you're trying to apply for a job and other things. As to Dave's point, as the county prosecutor, during the plea process, we had a very specific program set up by our assistant prosecutors. Only I and a very few number of my higher level staff were given the authority as to whether or not to approve somebody for the program. So we made sure they were the right people, that they would be successful, because you only get the program once in the state of New Jersey. And if you violate any of the conditions of the program, or if you get convicted of an offense down the road, you can never use it again. And I think Dave's going to give us a little bit of a thumbnail with respect to the eligibility requirements. So it's a very complex statute. We'll try to break it down in a way that makes sense to the average person that's looking into this area of law.
Yeah, like you said, Bob, and I think one of the most critical highlights that I could give to our viewers is that you only get this once. And it's available in the Superior Court for crimes, but there are also comparable programs in the municipal courts. Conditional discharge is one for drugs, and that's been around for a long time. And also there's a relatively new program called the Conditional Dismissal Program in the municipal court for non-drug offenses. Now, if a defendant has been given this program, the pretrial intervention, the conditional dismissal, or the conditional discharge program before, then the individual will not be eligible for the program. So that's number one. That's the first thing we look to. And then also, I mean, as far as criteria, it's really up to the prosecutor. Yeah, it's a prosecutor's program because it diverts the defendants away from the traditional prosecution avenue and pathway into the diversion status. And when I say it's the prosecutor's program, I mean that first, there's going to be an interview with probation. And then the probation officer will recommend either rejection or entry. And that goes up to the prosecutor. And even if the defendant is rejected by probation, the prosecutor can still override probation. They can override probation that rejected or accepted. Ultimately, prosecutor gets the say. And it's very, very difficult to overturn a prosecutor's decision because that must be made in a motion to the superior court judge. And the standard is abuse of discretion. It's very difficult to get over the hurdle when the prosecutor rejects, because really the only question is, did the prosecutor take everything into account? Did they look at everything? So that's important for us. Bob, why don't you talk about the mitigation package we do? Because it's critical on our cases where we try to get pretrial intervention because we want to provide information that's helpful to our clients.
Yeah, that's a great tie-in, Dave. Like Dave said, it is really the prosecutor's playground when it comes to with very little judicial oversight. They give prosecutors a tremendous amount of discretion as to how they resolve their cases in the criminal justice system. One of the things that we do, and we notice this as prosecutors, and we practice it very heavily in our criminal defense practice, which we have kind of fashioned like a prosecutor's office. That's the way all of our team are former prosecutors, is the mitigation package. The mitigation package is the good man, the good woman stuff, if you will, where when a prosecutor is opening up a file and they're making decisions, for example, is PTI warranted in the case, you want to put your client's best foot forward then, not at sentencing or after sentencing, which many lawyers do. You want to be able to get the prosecutor who has the power to decide whether the case is going to go to the grand jury and whether they're going to hit the case hard or whether they want to give a person a break. So we try to humanize our clients, and we have a list of a number of checkmarked items that we give to each client and prepare an extensive package to the prosecutor. And it's not just, we found people would throw letters here and there about rehabilitation, or they did good, or you get a good character letter from somebody. That's not enough in our minds. We actually excerpt from all of those materials, prepare an actual brief, if you will, with citations to those materials as exhibits. And the reason we do that is when we start making our arguments for how to resolve a case, whether by plea or trial or pretrial intervention, we want the prosecutor to be prepared right from the beginning, before they've made their decisions on an individual person, to humanize that client and to say, this client is worthy of this break of pretrial intervention. This person is doing the right thing, will do the right thing, and they'll be exactly the reason why the pretrial intervention program was put into place. So it is imperative at the beginning of the case to aggressively hit a case in favor of your client, because think about it, folks. This is the last point I'll say on this. When a prosecutor opens up the file, those files come in like the mail, and all they see is bad stuff in a file. There's never been a prosecution file against a defendant that says, hey, this is a really good guy, this is a really good woman. It says, no, these people have actually committed a crime, an offense against the state. So it's important for us to balance that playing field off right from the beginning. And we have found it to be tremendously successful, especially with regard to getting the prosecutor on board with respect to pretrial intervention, where basically they hold all the cards. If they want it, thumbs up, you get it. If they don't, thumbs down, you don't.
Yeah, sure. A very good option for really first-time offenders. That's who it's really eligible for. You could have a conviction and be eligible, but it's very difficult to get into pretrial intervention with a prior conviction. Now, Bob, as you recall, we had that Ray Rice case in New Jersey, right? The football player, the Rutgers football player who went to the NFL, was with the Ravens. And there was a TMZ video that came out in the elevator down in Atlantic City where he punched his wife, right? And he got pretrial intervention down in Atlantic County. And that was a big national case. It came out, and it actually affected our law. The legislators in the state of New Jersey changed things. And one of the biggest things that they changed was this thing called a conditional plea. Now, historically speaking, you didn't need to admit your guilt to get into pretrial intervention. That was just a diversionary program, and it was great because you didn't have to admit to anything. And then if you successfully complete, it gets dismissed. After Ray Rice, that got changed. There are certain circumstances that require conditional pleas. And I'm just going to list them. I'm going to toss it to you, Bob. For the situations where we need conditional pleas into pretrial intervention are for first and second degree crimes, if the defendant had a previous conviction for a first or second degree crime, if it's a domestic violence case, third or fourth degree domestic violence charges, or even disorderly person or petty disorderly persons offenses involving domestic violence, if the restraining order, if a temporary or a final restraining order was existing at the time of the petty disorderly persons offense or the disorderly persons offense. Conditional pleas are critical to know. Bob, why?
Well, you know, like Dave said, when this program was initiated, you didn't have to plead guilty or not guilty. You just got into the program. But there's two practical components to this new change in the law with this requirement for a conditional plea, as Dave has just indicated, that are very important. If you fail out of the program, the pretrial intervention program, you didn't pay your fines, you didn't do your community service, what have you, there's no going back to square one and arguing that there's a trial and a new plea bargaining process. You've already admitted your guilt. So that goes right to a sentencing phase, if you will. There's no more negotiations. And the second part of it is that there are a number of defendants who say that I am not guilty of the offenses charged, or I'm guilty of something less. And the pretrial intervention program was a good place for them to go into. But if you can't get a factual basis, that is something that says I am guilty of doing this domestic violence, say in that particular instance, then you can no longer get the pretrial intervention program. So a lot of lawyers, both prosecutors and defense lawyers alike, were like once again kind of saying to ourselves, wow, okay, we get the Ray Rice thing was a terrible thing. There were mechanisms in the criminal justice process where they could have prosecuted him. He was an eligible candidate for pretrial intervention, but because of the national notoriety, the legislators responded, as they often do, and changed 40, 50 years worth of law in order to say that they're doing something they think is positive. In the end, the consequences in court sometimes can be the opposite of what they thought they were attempting to achieve in the beginning.
Yeah, great points. I mean, historically, and if there's no conditional plea, then you don't go right to sentencing. That's the critical distinction there. I mean, if it doesn't require a conditional plea and the defendant violates, and Bob, one of the things that could violate a defendant is a new arrest. I mean, that's one of the more frequent triggers that violate pretrial intervention defendants. If there's a conditional plea and there's a violation, the defendant goes to sentencing, then they will have a conviction because of the conditional plea that they previously entered. But if it's not a conditional plea, then the defendant goes back to square one. You go back to court with the prosecutor, and the defense attorney could re-engage in plea negotiations. And usually if somebody fails out, violates pretrial intervention, the next step up is probation or a county jail sentence or even state prison. That's why it's so critical for first-time offenders to have this option available to them, because ultimately they could get out of potentially giving a factual basis or a guilty plea. And then ultimately, if they successfully complete, it could be gone, dismissal, just like a not guilty in front of a jury, just like an administrative dismissal by a prosecutor. So an excellent option when available, and we do everything we can to get our clients in that are eligible, and we use those mitigation packages to try to advance that position. Final thoughts, Bob?
No, I just hope that these, it's a very complex topic area, and of course the law is changing all the time, as Dave said. So if you were to ever have an issue or a family member or a friend, it's very important to consult an attorney, obviously, because they know the nuances of it. Each county does do things a little bit differently, and the law is constantly evolving. Ray Rice is a point to that. So we hope that these videos are helpful to you folks. We love doing them. Dave and myself are often lecturing to other attorneys and students, and so we hope you enjoyed it. If you have any questions, of course, you can always comment on the video.
Sounds good. From Bob and myself, thanks for watching. We are former prosecutors who aggressively fight the government when our clients are charged with crimes. Criminal defense, domestic violence, municipal court. Call us if you need us 24/7. Fill out a consultation request. We are advancing our technology as the days go by. We have Calendly available for appointments and calls, and we're here to service you guys. Thanks for watching. Have a great day.